CRMP 621 of 2025.
इसमें काउंटर फाइल करने के लिए कहा गया था। कन्फ्यूजन वाला एक कंप्लेंट केस है, लेकिन इसमें दूसरा तरह का ऑर्डर था कि कस्टडी रिपोर्ट मंगवा के काउंटर फाइल करने के लिए, तो हम उसको 1 हफ्ता का टाइम दिया।
इन्होंने तो अपना ऑर्डर लगाया ही हुआ है। इन्होंने तो अपने ऑर्डर में लगाया ही हुआ है ना। डेट ऑफ
ऑर्डर
अरेस्ट
लगाया हुआ है कि
कितने दिन का इनको सजा हुआ था?
जी
कितने दिन का सजा हुआ था? हाउ मेनी डेज?
3 महीने।
दिखाई जरा CRMP वो मेन रिवीजन पिटीशन।
इसमें इनका ऑर्डर लगाया हुआ है कि ये सर्व कर लिए हैं।
कितने दिन का सजा हुआ था? Three months. 3 महीना तो अकॉर्डिंग टू द ऑर्डर उन्होंने सर्व कर दिया। ठीक है, आपको अगर कोई ऐसा ऑब्जेक्शन होगा तो आप अपना रिवीजन हम रेस्टोर कर देते हैं, उसी में चेक कर सकते हैं। CRMP number 621 of 2025. Nobody appears on behalf of the petitioner. The learned counsel for the state is present. He has submitted that due to some confusion, he has not filed affidavit in terms of the last order. Upon verification of the custody of the petitioner in connection with complaint case number 1259 of 2017. However, after going through the materials on record, this court finds that one of the defects, it was surviving in Criminal Revision number 402 of 2020 was filing of surrender certificate. And on account of non-removal of defects, the Criminal Revision number 402 of 2020 was dismissed on 17/5/2024 due to non-compliance of preemptory order dated 3/5/2024 regarding removal of defects. It was submitted by the learned counsel for the petitioner on 28th of March 2025 that the sentence was only for a period of 3 months and the petitioner has served the sentence, and the same is supported by the order dated 24/1/2020, and a statement has been made that the petitioner, after serving out the sentence, was released on 23/4/2020. Considering the aforesaid facts and circumstances, the Criminal Revision number 402 of 2020 is restored to its original file. And office is directed to place the Criminal Revision before appropriate bench as per roster. The fact that the petitioner has served the sentence be brought to the notice of the concerned court who would deal with Criminal Division number 402 of the Internet. This CRM key is accordingly dispatched.
For hearing item 3, second April 56 of 2022.
No, Shep, in this case, I am appearing for respondent number 1 to 3 of notice.
The third possible. It must have happened.
You have got respondent number?
1 to 3, my lords. My client has instructed me that he does not want to pursue the case anymore. So his saying was that I said that we have to argue or something. He said, let the court pass any order. I said that you compromise. If you don't want to pursue the case, then compromise the case. He said, no, let the court on its own pass the order, Your Lordship. Therefore, he has engaged me to only to communicate the court that he does not want to pursue the case anymore. Though he was the degree holder in that appeal.
So possible.
पास ओवर करके कौन सा केस करें? बताइए। आपका पहला केस लगा होगा, आपको पहला केस में पास ओवर चाहिए? Yes. Sorry?
कुंदन कुमार मस्टा भी जानते हैं।
तो क्या करें हम? उनके घर चले जाएं? Yes. Dismiss पर डिफॉल्ट कर दें। इंस्टॉल कराते रहिए। करेक्ट? कोई है कोर्ट में केस बहस करने के लिए? बताइए कौन सा केस सब टेकअप करें? आज तो कोई नहीं आएगा, कोर्ट बिल्कुल खाली है, सारा केस हम डिस्मिस फॉर डिफॉल्ट करें। हमको क्या पड़ा है? आप लोग करना नहीं चाहते, व्हाई शुड आई बॉदर अबाउट इट? आई विल नॉट बॉदर। क्या बोल रहे हैं?
इन्फॉर्म करें।
इन्फॉर्म करके क्या करें? बुलाइए उनको, चलिए तब तक 2-4 केस डीएफडी कर देते हैं। अच्छा है।
My lords, my presence would be required.
आप of course your file वकालतनामा, your presence would be required.
Okay.
From daily list for final disposal, item 1, WPC 5781 of 2016, along with item 2 to 4.
Judgment name.
जी।
Mr. Ajit Kumar, this case will take some time because I am in the midst of the dictation. You can attend some other room for some time. I think 45 minutes I will take to.
आज 2:15 बजे थोड़ा हमको दिक्कत है।
नहीं, वो हम नहीं बोल रहे हैं, हम ये बोल रहे हैं कि आप आए हैं ये एज्यूम करके कि केस तुरंत टेकअप हो जाएगा, लेकिन अभी तुरंत टेकअप नहीं होगा, हम इसका कुछ डिक्टेशन
कोई
देंगे।
बात
After hearing the learned counsel for the parties, this court finds that in this batch of cases, the petitioners are dealers under Indian Oil Corporation, and all of them have entered into separate agreements with Indian Oil Corporation, hereinafter referred to as IOC, and agreements have been placed on record. सारे cases में agreements हैं. Agreements have been placed on record. The common feature of all the agreements is that the agreement itself revealed the status of respondent Indian Oil Corporation Limited, which is a company under the Companies Act 1956, having its registered office at Mumbai. And the petitioners have been granted dealership agreements. The agreement deals with various aspects of the relationship between the parties, and also deals with their mutual obligations. And also enables the respondent to terminate the agreement on account of violation of the clauses of the agreement. One important feature which has been relied upon by both the counsel for the parties is the faithful performance clause, which is present in all the agreements involved in this batch of cases, and the faithful performance clause has been placed from the writ petition being WPC number 5781 of 2016, which reads as under. कोट करेंगे. At page number 43 it is highlighted. The distributor undertakes faithfully and promptly to carry out, observe and perform all directions and orders or rules made from time to time by the corporation or its representatives for the proper carrying on of the distributorship of the corporation. Another feature of the agreement, another clause of the agreement which has been placed by learned counsel for both the parties, and since the respondent has relied upon the said clause, which is the clause dealing with resolution of dispute between the parties. The agreement clearly stipulates that all questions, disputes and differences arising under or in relation to the agreement shall be referred to sole arbitration. Of the director within bracket marketing bracket close of the corporation, and the provision in connection with arbitration is quoted as under page number 48. इसको मैंने mark किया है, page number 48 to 49. The writ petition was filed before this court on 30/9/2016, and the cause of action, so far as WPC number 5781 of 2016 is concerned, and the cause of action to file the writ petition was the order of penalty imposed upon the petitioner by referring to the marketing discipline guidelines of 2015, whereby a penalty of rupees 63,669 has been imposed, while order dated 30/8/2016 issued by respondent number 7. The order of penalty was preceded by an inspection, a show cause notice, a reply to show cause notice, and also a reply to show cause notice. The order of penalty the operative portion of the order of penalty, after discussing the response of the petitioner, has been given in a tabular form, and specific reference has been made to LPG Marketing Discipline Guideline 2015, and the nature of irregularities has been mentioned, and all the irregularities has been found to be first major or first minor irregularities. The nature of irregularities for which the penalty has been imposed is quoted as under पेज नंबर 58 का सब जगह ऐसा ही होगा in all these cases. It is further not in dispute that in all the writ petitions in the batch, similar tabular form has been mentioned by referring to the concerned LPG marketing discipline guideline. In other cases, it is LPG marketing discipline guideline of 2011. 2001. The petitioner being aggrieved by the order of penalty has moved this court challenging the legality and validity of marketing discipline guidelines 2015 for LPG or marketing discipline guidelines 201 for LPG, as the case may be, alleging that it is without jurisdiction and in contravention to the provisions of the control order, provision of liquefied petroleum gas within bracket regulation of supply and distribution bracket close order 2000, and also section 3 of Essential Commodities Act, and also violative of article 14 and 21 of the Constitution of India. The ये जो आपका एक और पेनल्टी था स्वास्तिक वाला, that was challenged in another writ petition, that is also a part of this batch.
1295.
The records of WPC number 5781 of 2016 further reveals that the same petitioner had filed another writ petition being WPC number 1295 of 2014, wherein a reference was made to the judgment passed by Karnataka High Court in WP number 37175 of 1999 with the bracket GM-RES Annexure 5 में मिलेगा, by which it was held that the Marketing Discipline Guideline 2001 lacks legislative competence, and therefore it was asserted in the said writ petition that the imposition of penalty by order dated 25/2/2014, which was subject matter of dispute in the said writ petition, being WPC number 1295 of 2014, was without jurisdiction. the order issuing notice in the said case has been placed in the records of WPC number 5781 of 2016 at annexure 5, which is dated 22/8/2014. The said writ petition being WPC 1295 of 2014 is also a part of the present batch of cases. From the entire records of these cases, this court further finds that during the course of arguments, the counsel for the petitioner has also submitted that the Marketing Discipline Guideline 2015 or Marketing Discipline Guideline 2001, as the case may be, is also violating of Article 77, 163 and 160.
77 and 166.
77 and 166 of the Constitution of India, and also that these guidelines have not been published in the official gazette, and therefore they do not acquire the status of law and are unenforceable in the eyes of law. However, in spite of, however, during the course of argument and even by dictating this order in open court, the learned counsel for the petitioner has not been able to show any such ground having been taken in the writ petition. This court further finds that so far as Constitution so far as Article 166 of the Constitution is concerned, the same falls under the Part 6 of the Constitution dealing with the states and it falls under Part 6, Chapter 2, dealing with the executive of the state. The Part 2 dealing with the executive of the state. And in the present case, the state government has no role to play, and therefore there is no scope of any argument by referring to Article 166 of the Constitution. So far as Article 77 of the Constitution of India is concerned, the same falls under the executive power of the union, and it falls under part 5 dealing with the union and chapter 1 dealing with the executive. And it deals with the conduct of business of the Government of India, and it also provides that all executive action of the Government of India shall be expressed to be taken in the name of the President. This court also finds that under Article 299 of the Constitution of India, it deals with the contracts made in exercise of executive power of the union or the state, which is expressed to be made by the president or the governor of the state, as the case may be. The very perusal of the agreement which has been placed on record reveals that the agreement is between a company registered under the Companies Act 1956 and the petitioner, though the Indian Oil Corporation is a government company, but the status of Indian Oil Corporation is of that of the company. The agreement has not been entered into by or on behalf of the President of India. The perusal of the agreement reveals that it is essentially within the contractual domain of the parties, and the agreement cannot be said to be governed by the provisions of Article 77 of the Constitution of India, and accordingly Article 77 of the Constitution of India has no role to play in the matter. It is also important, the aforesaid findings have been recorded in view of the fact that the counsel for the petitioner has raised the point during the course of argument with regard to Article 77 of the Constitution of India, though no such pleading was taken, and consequently the respondents did not have, including Union of India, had no occasion to respond to such an argument advanced on behalf of the petitioner. This court also finds that the nature of argument being contractual in nature and this court would not have entertained a repetition arising out of contractual dispute between the parties merely because the respondent is a government company. But since the validity of marketing discipline guideline was under challenge, the writ petition was entertained and the initial petition which was entertained was referring to the judgment passed by Honorable Karnataka High Court, wherein the marketing discipline guideline itself was 2001 was set aside, being lacking legislative competence. And in the present case, the penalty has been imposed by referring to the marketing discipline guideline. At this stage, it is also important to note that the respondent had raised, the respondent though have not filed any petition under section 8 of Arbitration and Conciliation Act 1996, but they have raised serious objection with regard to maintainability of the petition, so far as the legality and validity of the action taken under marketing discipline guideline is concerned, but they at the same time have argued and pleaded with respect to the legality and validity of marketing discipline guideline. The
Now that there was a statutory alternate remedy of arbitration has
Yes.
been taken up by us.
Yes.
And that
they have specifically taken the point regarding alternative dispute resolution in terms of arbitration, and the said point was kept open for consideration by the order dated. Yeah.
that order was passed in Tara
In
395. I think in this matter also that order.
yes, yes. Yes. By the order dated 18/1/2023, passed in WPC number 5781 of 2016.
But Tara 7.4 were counter affidavits.
And in all the counter affidavits, the plea regarding alternate availability of alternative remedy through arbitration has been taken. So far as the judgment passed by Honorable Karnataka High Court in WP 37175 of 1999 and batch of cases is concerned, the respondents have placed on record the division bench judgment. They have referred to the division bench judgment.
Along with the compilation.
In the compilation filed by them, and has submitted that the judgment has been reported in 2015 SCC Online Karnataka 2947 and has referred to paragraphs 11 to 14. Which is a division bench judgment, wherein Yes. Wherein the appeals were allowed and the order of the learned single judge was modified, holding that marketing discipline guideline framed on 2005 was binding upon all the dealers, whereunder clause 42 of the model agreement was incorporated in the dealership agreement entered between the parties. Such marketing discipline guideline was not applicable in respect of the dealers where clause 42 of the dealership agreement was not incorporated in the dealership agreement. The clause 42 of the agreement referred to in that judgment was also quoted in the judgment itself, which was essentially dealing with the obligation cast upon the dealer that they at all times faithfully, promptly and diligently observe and perform and carry out all the directions and instructions and guidelines issued by the corporation. Thus the judgment which has been relied upon by the learned counsel for by the petitioner in the writ petition does not help the petitioner in view of the fact that a different view was taken by Honorable Division Bench of Karnataka High Court in the judgment reported in 2015 SSC Online Karnataka 2947, wherein the marketing discipline guideline was upheld. A reference has also been made to the Division Bench judgment of High Court of Delhi in the matter of Indian Oil Corporation Limited versus All India Petroleum Dealers Association, reported in 2022 SSC Online Delhi 77, paragraph 37 to 44, by the respondents, to submit that even Honorable Delhi High Court has upheld the validity of marketing discipline guidelines, white paragraph 44 of the judgment, and the faithful performance clause in the connected agreement was clause number 43. In the said judgment, the Division Bench judgment of Karnataka High Court has been followed, and a reference has been made in paragraph 43 of the said judgment. Paragraph 43 and 44 of the judgment passed by Honorable Delhi High Court is quoted as under. तो कर्नाटका और वो दोनों आ जाएगा कोटेशन इसमें. Thus, by making reference to the aforesaid judgment passed by Honorable Delhi High Court and the Division Bench judgment passed by Honorable Karnataka High Court, this court finds that both the high courts have upheld the legality and validity of marketing discipline guideline, where faithful performance clause is available in the agreement between the parties. In the present cases, it is not in dispute that all the agreements have the faithful performance clause. And consequently, the this court also finds that no distinguishable feature has been drawn to the notice of this court so far as the aforesaid judgment passed by Honorable Delhi High Court and division bench of Honorable Karnataka High Court is concerned by the learned counsel appearing on behalf of the appellant petitioners. However, the counsel for the petitioners has submitted that has referred to the provisions of Essential Commodities Act, Section 3, and has also referred to the liquefied petroleum gas within bracket regulation of supply and distribution order 2000, which is the order framed under section 3. He has further referred to clause 11. He has further referred to schedule Roman 7 of the liquefied petroleum gas. यहाँ पे लिखेंगे LPG order 2000, वेरी आपका करके है ना, LPG order 2000 to submit that as per paragraph 6 to schedule Roman 7, there is a provision regarding marketing discipline guideline proposed to be adopted, and therefore the marketing discipline guideline ought to have been adopted in terms of the provisions of Essential Commodities Act, and the manner in which the marketing discipline guideline has been framed and applied in these cases is divorce the provision of Essential Commodities Act. This court finds that so far as LPG order 2000 is concerned, so far as schedule Roman 7 of LPG order 2000 is concerned, the same is referable to clause 11 within bracket 4 of the LPG order 2000, which deals with assessment and certificate rating of parallel marketeers. And paragraph 6 of schedule 7 refers to marketing discipline guideline proposed to be adopted. Essentially, the provisions of section 11 read with schedule 7 including paragraph 6 of schedule 7 is referable to parallel marketeers and has got no applicability so far as the petitioners are concerned, who certainly do not fall within the meaning of parallel marketeers as defined under LPT Order 2000,
Regulation 2J.
Regulation 2J, J and K, which are quoted as under. In view of the aforesaid facts and circumstances, this court is of the view that the reference made to Schedule 7, framed under Clause 11 within bracket 4 of LPT Order 2000, read with paragraph 6 thereof, has no relevance in the facts and circumstances of this case. Further argument of the petitioner is by referring to the Essential Commodities Act 1955 and it has been submitted that the entire gamut of affairs in connection with essential commodity of LPG is governed by section 3 read with LPG Order 2000. Anything else? Section 3 read with LPG Order 2000 and the violations mentioned therein has penal consequences in terms of imprisonment and also imposition of fine. And accordingly, there further cases that once there is provision for imposition of fine under Essential Commodities Act, there can be no imposition of penalty under the marketing discipline guidelines. And therefore, the petitioners cannot be subjected to double penalties, one under Essential Commodities Act and another under marketing discipline guidelines. This court finds that the aforesaid arguments advanced on behalf of the petitioner is not acceptable in view of the fact that the provisions of Essential Commodities Act are dealing with criminal liability arising out of the violations mentioned therein and the penalty which has been prescribed is under section 7 thereof, which provides that if any person contravenes any order made under section 3, he shall be punishable by imprisonment which may extend to 1 year or 7 years, and also liable for fine. It also provides that any property in respect of which the order has been contravened shall be forfeited to the government. This court is of the view that the prescription for imposition of imprisonment and fine, as mentioned therein, arises out of a criminal liability created under the Essential Commodities Act 1955, and section 3 thereof and violation of provisions of section 3 thereof or the orders framed thereunder. In the present case, as held by Honorable Delhi High Court and also held by Division Bench of Honorable Karnataka High Court, the marketing discipline guideline is referable to faithful performance clause, and the purpose of framing marketing discipline guidelines 2015 has itself been mentioned in the introduction of marketing discipline guideline 2015, which has been placed on record by the petitioner in WPC number 5781 of 2016, which reads as follows. Upon perusal of the very purpose of introduction of marketing discipline guideline, this court finds that the same has been framed to meet the requirements of the LPG consumers, as the LPG marketing is unique and LPG consumers are tied up to LPG distributors with very little freedom to choose their distributors. And the marketing discipline guideline itself refers to the faithful performance clause. It has been framed to meet the challenges of growing customers' expectation, ensuring quality of product and services, enforcing discipline amongst the distributors' network, and prevent malpractices in the sale of petroleum products. This court also finds from the perusal of marketing discipline guidelines that various categories of minor and major irregularities, including critical irregularities, has been enumerated, and the punishment has also been prescribed as to first instance, second instance, third instance, and so on. These details with regard to the nature of irregularities, details of the nature of irregularities and the consequence flowing thereof, be it first, second, third, and so on irregularities, has not been detailed and described in the main agreement. And this marketing discipline guideline is essentially for the purposes of supplementing is for the purposes of detailing the for the purposes of is by way of guidelines to both the distributors and the oil companies. This court is of the considered view that the marketing discipline guidelines are essentially referable to the faithful performance clause as per its introduction itself, and the contents of the marketing discipline guidelines also serves the purpose to ensure that the faithful performance, that the parties act in terms of the faithful performance clause. This court is of the considered view that the marketing discipline guideline is neither arbitrary nor illegal, nor the same can be said to be violative of any provisions of the Constitution of India or any provisions of the Essential Commodities Act. The Learned Council has also referred to the Marketing Discipline Guideline of 2001. किस रिकॉर्ड से रेफर किए थे? किस रिकॉर्ड से रेफर किए?
395 to 2011 Tara
जी। Page 73. हाँ. Wherein a reference has been made to letter dated 10/5/2001, which has been issued by Indian Oil Corporation, by stating that the revised Marketing Discipline Guideline 2001 for LPG was being circulated as approved by Government of India. This court also finds that under the LPG discipline guideline, under the Marketing Discipline Guideline of 2001, a chart has been prescribed giving the details of the irregularities and the proposed action arising therefrom. To be imposed in terms of marketing discipline guideline. Under the Marketing Discipline Guideline 2001, no provision of appeal has been proposed since there, by referring to the existing provision under the agreement which is said to be sufficient. This court is of the considered view that merely because the Marketing Discipline Guideline 2001 refers to the approval of the Government of India, the same does not make any difference with regard to the nature of Marketing Discipline Guideline, which is essentially referable to the faithful performance clause of the agreement. Apart from so far as the right of appeal is concerned, it essentially depends upon the agreement between the parties and the right and remedies are governed by the agreement, and in the present case there is a provision of arbitration.
In all the cases, arbitration
Yes, yeah.
clause is there.
I have recorded that. There is no dispute on that. मुझे जर्नल्स का कॉपी निकालना था। ये है ना। Contract Act did it. So far as the judgment relied upon by the petitioner reported in bracket 1977 volume 2 SCC 22 is concerned, the issue involved in the said case was as to whether the SSEs could be made liable for penalty under the provisions of State Sales Tax Act. In the said case, the penalty was imposed under the State Act for default in payment of taxes. It was in the context of imposition of taxation and consequent imposition of penalty under taxation, which was under consideration in the said case. And it was held that the imposition of penalty gives rise to a substantive liability which could be viewed as an additional tax or as a fine for the infringement of law. And that the imposition of pecuniary liability which takes the form of penalty or fine for a breach of legal obligation cannot be relegated to the region of mere procedure and machinery for realization of tax, and that neither a pecuniary liability can be imposed nor an offence can be created by mere implication. it was also held that such liability must be created by clear, unambiguous, and express enactment. And a reference was made, and reliance was made also to Article 265 of the Constitution of India, which clearly provides that no tax shall be levied or collected except by authority of law. This court is of the considered view that the said judgment has no applicability to the facts and circumstances of this case, in view of the fact that this court finds that the imposition of fine through the LPG guideline is essentially a civil liability created under the guidelines, and the guidelines are themselves referable to faithful performance clause of the agreement. In the judgment passed by Honorable Supreme Court, which is reported in 2019, which is reported in bracket 2019, bracket close 19, SCC 662. Wherein the dealership, wherein the termination of dealership by referring to marketing discipline guideline was set aside by the High Court, and Indian Oil Corporation was in appeal before the Honorable Supreme Court. An argument was advanced that the Indian Oil Corporation was required to follow the procedure under the control order read with section 100 of CRPC, and a reference was also made to section 3 of the Essential Commodities Act. Such plea was categorically rejected by the Honorable Supreme Court, and the Honorable Supreme Court observed that the dealer in the case was not sought to be prosecuted for violation of the guidelines, and therefore procedure for drawing the sample, which was necessary precondition under the control order for prosecuting an offender, did not arise. Meaning thereby the Honorable Supreme Court made a clear distinction in the circumstances where the Indian Oil Corporation could choose to prosecute a person under the control order issued under the Essential Commodities Act, and otherwise choose to proceed under the marketing discipline guideline. The paragraph 14 of the aforesaid judgment is quoted as under. This court finds that overlapping instances of a criminal liability arising out of Essential Commodities Act and a civil liability of imposition of fine under the marketing discipline guideline, but they certainly operate in different fields. And this court is of the view that merely because there is a provision for prosecution and imposition of fine by way of criminal liability under Essential Commodities Act, it cannot be said that fine cannot be imposed upon the dealer by referring to marketing discipline guideline. Should I refer to section 74 of the Contract Act, which also provides for penalty? Penalty under the contract is not something which is alien.
That we have not, it answers the one of the contentions of the petitioner that we have not been able to show the loss, the corroborating loss to the amount.
That's
In fact,
so section 74 of the Contract Act clearly provides
for a contractual penalty.
for Contract Act itself provides for penalty for violation of terms and conditions of law.
Yes, and 73, 74 is for
Yes.
two separate purposes.
Two separate purposes,
But
penalty is contemplated under
yes,
civil law.
absolutely.
That should be sufficient because
Yes.
the rest I will leave it for the advocate.
Yes.
I will not say. This court is further of the view that even under the Indian Contract Act, Section 74 contemplates imposition of penalty for breach. Therefore, the argument of the counsel for the petitioner that there can be no imposition of penalty under the marketing discipline guideline is devoid of any merit. एक तो और जजमेंट है, हम उसको डील कर लेंगे. आई विल डिस्टिंग्विश. एक आध जजमेंट्स और है आपका जो आप देख सकते हैं. आई विल जस्ट डिस्टिंग्विश. असल में वो कंप्यूटर में मैंने मार्क किया था, तो ये प्रिंट आया है, तो वो मार्क्स पोर्शन मेरा इसीलिए आई एम जस्ट टेकिंग टाइम ऑन दैट. बाकी आई थिंक कुछ और छूटा है आप लोग का. आई थिंक आई हैव कवर्ड एवरीथिंग. आई हैव रेफर्ड टू सेक्शन 74.
At one place, your lordship, in finding your lordship was observing that what was the purpose of MDG
उसको
guideline?
कोट कर दिया.
I have said that for the purpose of facilitating the process of controlling the distribution network so that the ultimate consumers may get quality service. So
वो
that-
मैंने उसी में से जो पोर्शन है ना, उसी से कोट कर दिया.
हाँ, ठीक.
उसमें से कुछ पोर्शन में कोट कर दूँगी. I don't want to add any word to that
ठीक,
because
ठीक.
that
एकदम
provision is already there. उन्होंने खुद ही उसको delete
and
किया
it is put in that after long drawn process of thought.
हाँ. This court finds that so far as the challenge to marketing discipline guideline is concerned, the same does not call for any interference, and the marketing discipline guideline which are included in the present set of the petitions are upheld. So far as the imposition of penalty, the imposition of fine
Fine or penalty.
fine or penalty under the marketing discipline guideline with respect to violation is concerned, this court is not inclined to interfere with the same, keeping it open to the petitioner to avail the remedy through arbitration. In view of specific clause of resolution of dispute through arbitration, the petitioner would avail the remedy of arbitration in terms of the clause read with the provisions of in terms of the said clause read with the provisions of arbitration and conciliation. क्योंकि उसमें एक named arbitrator है ना, वो तो बनेगा नहीं
नहीं ठीक है
है ना, in terms of the
Absolutely,
provisions of
absolutely.
वो तो नहीं बन सकता
नहीं नहीं कभी नहीं
उसपे एक टाइम फ्रेम दे देते हैं या in accordance with law. In accordance with law. हर एक केस का date of filing and date of impugned order देना जरूरी है.
2 additional lines of RM service was important. Your Lordship has read in para 18 last 3 lines it says, in this case since the stock variation was beyond permissible limit and the sample failed, therefore the action was rightly taken under clause so and so of the guideline, which is a critical irregularity when read with so and so of the guideline. So it was, the Honorable Court found that it was in terms of the guideline. Last 4 lines of para 18. And then last 2 lines, 3 lines of para 19.
Paragraph 18, 19 are quoted as under. ये वाला 19 वाला judgment है ना. देखिए para 19 वाले judgment का 2-3 पैराग्राफ आपको कोट करना है. para 14 आपने लिख लिया है पहले, ठीक है. उसके बाद para 15, then para 16. The purpose of guideline has also been mentioned. Paragraph 16, then 18 and 19. ठीक है.
citation नहीं पड़ती.
हाँ, citation is 2019 bracket close 19 SCC page number 660. आपको इसमें जहाँ से भी कुछ भी लेने में दिक्कत हो तो आप खोजने में टाइम मत वेस्ट करिएगा, हमसे पूछ लेंगे. These petitions are accordingly disposed of by holding that LPG Marketing Discipline Guideline 2001 or 2015, both are upheld, and so far as the merit of the penalty is concerned, it will be open to the petitioners to avail the remedy through arbitration. That's it.
Only one word, Your Lordship. Our
In accordance
LPG
with law.
guideline is valid and therefore Your Lordship is upholding.
The legality and validity of the MDT guideline which is under challenge is upheld.
So, Lordship, on the point of arbitration, whether any time frame is being
I've not given any time frame, but you should remove any of the list. Because I
accordance with
find
law.
that in most of the cases you have immediately moved the code. That date will be there in my judgment. Right? तो अब आपने move किया है. So this liberty I have already given you. Because arbitration अपने आप में अलग ही कहानी है. उसमें कुछ भी बोलना, liberty देना बहुत मुश्किल है. लेकिन एक चीज है कि आपको बिना 11(6) के हो नहीं पाएगा, क्योंकि इनका जो है ना आर्बिट्रेशन क्लॉज में उन्होंने एक पर्टिकुलर अथॉरिटी को ही अपने ऑफिसर को नियुक्त कर रखा है. तो नाउ आई थिंक अंडर 11(6) एंड इंडिपेंडेंट
First they'll issue a letter.
फर्स्ट यू विल इशू अ लेटर, दैट इज द
We may agree to name of any independent arbitrator.
कोई भी एक इंडिपेंडेंट आर्बिट्रेटर.
From Credit List Item 5, WPC 4007 of 2020.
You have filed your affidavit. It is registered.
Yes, we have given a statement in the article saying that the lease deed was registered.
Next. Password.
Passover case from Supplementary List Item 6, Second Appeal 56 of 2022.
Respondent says he has nothing to argue. He has been instructed not to argue.
He has also informed me that
बात ये है कि अब उनके इंस्ट्रक्शन से इसलिए नहीं चलेगा क्योंकि एक substantial question of law frame
or
है.
has already been framed by the
So therefore that has to be answered. If he has nothing to say, we will say that he has nothing to say. Right? But you have to be here. वकालतनामा फाइल किए ना, कोर्ट
हाँ
छोड़ के नहीं जा
ठीक है,
पाएंगे.
मैं
चाहिए. अभी थोड़ी देर में डिसाइड होगा.
छोटा सा मैटर है.
छोटा सा.
छोटा सा matter.
हाँ बताइए.
This is a plaintiff second appeal against the judgment of requirements, and this second appeal was admitted by order dated 13 to 2025. Order number 9.
थोड़ा इसको पढ़ेंगे ऑर्डर.
जी.
हाँ पढ़िए. इसमें सारा कुछ लिखा ही
इसी
होता
में
है.
पूरा आंसर हो जाएगा, फिर बहस करने की जरूरत ही नहीं पड़ेगी.
जी.
और रिमांड भी हो जाएगा अकॉर्डिंग टू अस लॉर्डशिप.
पढ़िए.
May I read out?
हाँ yes.
Had learned counsel appearing on behalf of the appellant, learned counsel for the appellant had submitted that the appellant was plaintiff before the learned trial court and suit property was a flat of housing lot. The prayer in the suit was that the defendant number 1 to 3 were not entitled to evict the plaintiff forcibly till the pendency of the prayer before the defendant number 4. The original allotment was made in favor of the defendant number 2, which was prior point of time, and plaintiff came in occupation of the suit premises, and their prayer for allotment was pending before the defendant number 4. He submits that in this suit, a counterclaim was filed by the defendant number 2, asserting that defendant number 2 was legally allotted the quarter and was ready to deposit the arrears of rent to the housing board and had valid right to get the said quarter in vacant position from the plaintiff. It was asserted that by the defendant number 2 that the plaintiff was only having permissive possession. There was no allotment in favor of the plaintiff. The defendant claimed relief through counterclaim that quarter must be handed over to him without any objection, and defendant number 2 claimed that declaration of right over the said quarter allotted to him by the defendant number 4 on 18/3/1994 and claimed that plaintiff was liable to be evicted.
एक बार जरा दोनों का केस पैरेलली बताएंगे तो. प्लेंटिफ का क्या केस था?
Plaintiff case है कि the government have constructed a number of the residential house for the employee of the housing board as well as needy person lordship. The housing board allotted the quarter to the defendant number 2, but the plaintiff was possession of the land.
Defendant number 2 was allotted.
But the plaintiff was possession of the quarter lordship.
How was the plaintiff in possession?
Lord, he was admittedly he was possession of the quarter lordship.
Illegal possession.
Illegal, yes, he was possession of the land lordship.
That's it. He
But
was
the
in possession.
But the defendant number 2 did not pay the rent lordship. The plaintiff had paid all the rent lordship. Thereafter suit was filed. During the suit lordship,
the said quarter has been allotted to plaintiff lordship.
What is the date of allotment to defendant number 2?
In the year 1984 lordship.
1994. What is the date of allotment to the plaintiff?
It has come out a lot that during the pendency of the suit, the quarter has been allotted to plaintiff lordship. And the defendant number 2 also filed counterclaim lordship, but which was not registered lordship. According to law lordship, the counterclaim is required to be registered lordship. But finding was given by the learned trial court is that the counterclaim was dismissed. Against the order of the counterclaim, the defendant number 2 preferred title appeal lordship, which was also which was allowed. Against which lordship this
So defendant number 2 filed counterclaim.
Counterclaim.
Counterclaim, which was dismissed.
One line finding है कि
Counterclaim is
counterclaim was
but it was
dismissed.
never registered.
But no evidence was adduced either by the party.
Did he pay any court fees on counterclaim?
Lordship, I am not aware, Lordship.
इसीलिए हम record
Counterclaim
counterclaim was registered or not is something.
Even if
which is
lordship court fee was paid and it was not registered lordship.
Unless you are called for to file your written statement to the
Yes,
counterclaim.
by the plaintiff as well as lordship other defendants lordship.
सिर्फ टाइटल सूट का जजमेंट है, काउंटर क्लेम का तो कोई जजमेंट ही नहीं है।
काउंटरक्लेम का जजमेंट आया हुआ है, लास्ट लाइन देखा जाए।
हाँ, बस उतना ही भरा है।
बस उतना ही भरा है और उसमें कोई रजिस्ट्रेशन
कोई नंबर भी नहीं है, कुछ
नंबर भी नहीं है। अब सिर्फ लिख दिया है काउंटरक्लेम वाज डिसमिस्ड व्हिच इज रिक्वायर्ड टू बी रजिस्टर्ड।
इशू में काउंटर क्लेम का कोई इशू फ्रेम हुआ?
नहीं, कोई फ्रेम नहीं हुआ। इशू पारा फॉर लॉर्डशिप में काइंडली सी इशू फ्रेम बाय द लर्नेड ट्रायल कोर्ट लॉर्ड। नहीं, इशू भी काउंटर क्लेम पे इशू भी फ्रेम नहीं हुआ। इशू फ्रेम नहीं हुआ इसलिए एविडेंस भी नहीं हुआ। रिटन स्टेटमेंट भी मेरे द्वारा फाइल नहीं हुआ।
इशू हुआ ना, बस वो फाइल करके पड़ा रह
गया। मेरा फाइंडिंग्स आ गया कि डिसमिस कर दिया गया काउंटर क्लेम को। कोई गवाही भी नहीं हुआ उस काउंटर क्लेम पर।
दिख तो नहीं रहा है कोई ऐसा टाइटल सूट में।
नहीं, हम तो देखें इसमें कहीं भी नहीं है, इशू भी फ्रेम नहीं हुआ।
इनका जो काउंटर क्लेम जो भी है, जो भी इन द फॉर्म ऑफ काउंटर क्लेम इन्होंने फाइल किया था वो है कहाँ? वो भी तो होना चाहिए।
होना भी चाहिए, मेरे पास भी नहीं है।
ये सिर्फ टाइटल सूट है। रिटन स्टेटमेंट इन्होंने फाइल किया है, डिफेंड नंबर 4 का रिटन स्टेटमेंट
हाउसिंग बोर्ड का है।
Who is for housing board in this case?
Notice was issued to the housing board also, Lord, which was bilaterally served.
But they are not interested. Written statement filed on behalf of defendant number 1 to 3. Okay.
जी।
आपका कहना है कि
डिफेंडेंट नंबर 1 to 3 का केस है कि सेक्शन 80 का कंप्लायंस नहीं हुआ of the CPC, but no relief was claimed against the state. Therefore, no notice is required to be sent to the state, Lord.
issue number 6 देखिए तो।
Issue number 6. Whether the defendant number 1 and 3 have right to evict the plaintiff from the suit premises. इसका फाइंडिंग
काउंटर क्लेम से ही है ना?
हाँ, इसमें सारा है। पारा 15 में एक साथ डिसाइड किया गया इशू नंबर 1, 2, 3, 4, 5 एंड 6। पारा 15 इंटरनल पेज 11।
खाली रिटन स्टेटमेंट दिख रहा है ना, तो काउंटर क्लेम होके तो कुछ दिख नहीं। वो प्लेंटिफ इज लायबल टू बी इविक्टेड, इन्होंने काउंटर क्लेम होके तो कुछ किया ही नहीं। अपॉन एडजुडिकेशन द राइट ऑफ द डिफेंडेंट।
एक लाइन लिखे हैं, hence the suit is hereby dismissed along with counter claim. लास्ट लाइन है, पेज इंटरनल पेज 30, एकदम लास्ट लाइन।
एक देखिए, जो रिटन स्टेटमेंट इन्होंने फाइल किया है ना,
जी,
उसी में पैरा नंबर 29 के बाद एक काउंटर क्लेम
काउंटर क्लेम कहाँ, ऐसा भी होता है
हाँ,
कि रिटन
Written
स्टेटमेंट भी
statement
काउंटर
का
क्लेम भी हम कर
counter claim।
सकते हैं, इसमें
ठीक है।
कोई डिस्प्यूट नहीं है।
हाँ, लेकिन उसको भी तो रजिस्टर करना
रजिस्टर
होता है।
करना पड़ता है। देयर इज दिल्ली हाई कोर्ट जजमेंट लॉर्डशिप, मे आई रेफर लॉर्डशिप, पैरा 6 लॉर्डशिप।
देखिए, पैरा 14 में लिखा है, फॉर द पर्पसेस ऑफ कोर्ट फीस एंड जुरिसडिक्शन द काउंटर क्लेम इज वैल्यूड एट ₹30,000 एंड फॉर विच डिफेंडेंट नंबर 2 इज रेडी टू फाइल कोर्ट फीस देयरऑन फॉर एडजुडिकेशन ऑफ हिज क्लेम। लेकिन ऐसा तो कोई कोर्ट फीस जमा
करता
किए
तो
हैं।
हाँ रिकॉर्ड्स में भी आ जाता है।
एक सेकंड चेक करना जरूरी है ना, रुक जाइए। 13/5/2013 के बाद ही आया होगा कुछ भी ऑर्डर शीट में। ऑर्डर 10 रूल 1A क्या हुआ?
Order 1.
ऑर्डर 10 रूल 1A, ऑर्डर 10
इसमें तो कुछ जजमेंट में भी नहीं आया।
क्या है? क्या प्रोविजन?
Order 1 Rule 10 है।
ऑर्डर 10 रूल 1A।
Direction of the court to of any one mode of alternative dispute resolution. अच्छा अच्छा, ये mediation के लिए है। mediation के लिए जैसे कोई सूट फाइल होता है तो ऑर्डर 10 में भेजा जाता है मीडिएटर के पास।
देखिए इसमें एक डिटेल्ड ऑर्डर भी है that there is a counter claim, is a detailed order about this। अब देखिए जरा ऑर्डर शीट, आप ऑर्डर शीट देखिए 13/5/2013 के बाद।
तेरा पास हो सकता है।
आपको तो मौका थ्रू आउट दे रहे हैं उसको रिस्पॉन्ड करने के लिए,
जवाब फाइल नहीं।
आपने जवाब नहीं फाइल किया। आप ये कैसे बोल रहे हैं आपको रिटन स्टेटमेंट फाइल करने का मौका नहीं मिला? ऐसा तो नहीं है, आपको तो काम जो भी इन्होंने रिटन स्टेटमेंट फाइल किया उसका जवाब देने के लिए आपको कई बार टाइम मिला।
ठीक, हम जवाब नहीं दिए तो उसको रजिस्टर तो करेंगे ना काउंटर क्लेम को। एडवेलियरम कोर्ट फी तो देंगे ना, तो कोर्ट फी भी नहीं आए जो हम ऑर्डर भी पढ़ रहे हैं, जो कोर्ट फी भी नहीं दिए हैं। ठीक, हम जवाब नहीं दिए हैं।
ये कहीं ट्रायल कोर्ट के और उसके जजमेंट में आया है कि इसको कोर्ट फीस भी
नहीं, सब कुछ नहीं आया है। 12-15 लॉट्स को देखो, इशू नंबर 1, 2, 3, 4, 5 and 6 पर डिसाइड हुआ। मेन इशू है इंटरनल पेज 11। यू लॉर्डशिप गॉट इट।
एक सेकंड, ट्रायल कोर्ट का जजमेंट में पहले इशू देखते हैं
जी, पैरा 4 लॉट्स, पेज 6, इंटरनल पेज 6।
यहाँ पर उसके पहले पेज नंबर 5 में लिखिए द डिफेंडेंट आल्सो क्लेम रिलीफ थ्रू काउंटर क्लेम। उसके बाद पेज 6 में इशू है ये।
हाँ, इशू है।
पेज 6 में रोमन 6 जो है
जी,
इट इज डायरेक्टली रिलेटेड टू काउंटर क्लेम, करेक्ट?
but what was the occasion for filing counter claim lawsuit? If the issue has already been framed on the basis of pleading of the written statement and as well as plaint lawsuit, which is required to be registered. Let's say I have referred
No,
the
because the defendant was seeking a relief through counterclaim. भाई अगर मान लीजिए डिफेंडेंट को आपको इविक्ट कराना है तो उसको काउंटर क्लेम तो फाइल करना
yes,
पड़ेगा ना.
but he has to pay the ad valorem court
we
fee.
will see that ad valorem court fees की बात हम करेंगे and then
And counterclaim is also required to be registered in view of the judgment passed by the Honorable Delhi High Court in Para 6 Lordship.
certainly.
But issue was also required to be framed relating to counterclaim Lordship.
काउंटर क्लेम नहीं लिखा है लेकिन है तो वही.
है मगर उसका भी इशू बनेगा, counterclaim का भी इशू बनेगा.
इसका ट्रायल कोर्ट का डिक्री आप फाइल किए हैं क्या? नहीं फाइल किए.
डिक्री में भी counterclaim का कोई जिक्र नहीं.
वो हम देखना चाह रहे हैं इसमें.
यहाँ दिखा the defendant number 1 to 2 paid the relief paid by the defendant number 1 to 3 cannot be decided in its favor in view of the allotment made in favor of the plaintiff. but judgment में तो dismiss कर दिए counterclaim.
ट्रायल कोर्ट का डिक्री किधर है?
ट्रायल कोर्ट का डिक्री है मेरे पास.
दिखाइए जरा.
सूट में बोल दी कि infractions हो गया क्योंकि during the pendency of the suit the quarter has been allotted to the plaintiff.
Suit was also valued at 30,000 only. इसको देखिए. अब आप दिल्ली हाई कोर्ट का जजमेंट दिखाइए.
दिए 12 lots निकालेंगे.
ये है.
जी 12
पहले फैक्ट पढ़िए. बिना फैक्ट के कोई जजमेंट नहीं है. फैक्ट. The petition challenge.
challenge the rejection of the plaintiff application seeking condonation of delay in filing the written statement to the counter claim of the defendants. The plaintiff filed a suit for recovery against the defendants, and the defendants filed a counter claim seeking adjustment and compensation. The trial court rejected the application based on the presumption that time limit of 120 days for filing written statement is mandatory under the Commercial Code Act. Finding the court found that there is ambiguity regarding the registration of the counter claim and time limit to filing a written statement. It held that counter claim must be registered by the court before the time for filing. Before the time for filing a written statement can come in, the court permitted the written statement to be taken on the record, subject to payment of cost and directed expeditious proceeding under the Commercial Code Act. The issue revolved around the registration of the counterclaim, ambiguity in timeline for filing the written statement, applicability of the Commercial Code Act. The court decision was influenced by the interpretation of Order 8 Rule 1 CPC, Order 8 Rule 6 CPC, and Order 4 Rule 1 and CPC, which clarified the requirement for registration of the counterclaim and timeline for filing the written statement in commercial suit. The written statement to the counterclaim was permitted to be taken on the record, and the suit was counterclaim directed to proceed under the provisions of Commercial Code Act 2015. The court also issued guidelines for registration of counterclaims to avoid the ambiguity in the timeline for filing written statement. The present petition challenge the order dated
नहीं वो तो देख लेगा
जी।
आप conjoint pleading जो
Paras clause.
पहले ना provision of law ही पढ़ लेते हैं इसमें quoted है सारा है ना
Order 8 Rule 6.
6A हाँ
Counterclaim by the defendant. A defendant in a suit may, in addition to his right of pleading, set off under Rule 6, set off by way of counterclaim against the claim of the plaintiff any right or claim in respect of a cause of action occurring to the defendant against the plaintiff either before or after filing of the suit, but before the defendant has delivered his defense or before the time limit for delivering his defense has expired, which such counterclaim is in nature of the claim for damage or more, provided that such counterclaim shall not exceed the pecuniary limits of the jurisdiction of the court. Such counterclaim shall have the same effect as a cross suit, so as to enable the court to pronounce a final judgment in a suit, both on the original claim and on the counterclaim. The plaintiff shall be at liberty to file a written statement in answer to counterclaim the defendant with such period as may be fixed by the court. The counterclaim shall be treated as a claim governed by the rules applicable to the plaintiff.
आगे orders 4
Order 6.
order 4 rule 1 and 2
Order 4 Rule 1.
requires every plaint to be registered by the court. The suit was dismissed.
Suit was dismissed on the ground that during the pendency of the suit, the quarter has been allotted to the plaintiff.
No, that was not the ground.
Yes.
There was no evidence that the allotment in favor of the defendant has been cancelled prior to allotment in favor of the plaintiff.
Yes. There is no evidence that
That it was cancelled.
can cancel. But it is true that the quarter has been allotted to the.
So that is okay, it is true. But the reason for dismissal of suit was that there was no cancellation of allotment of the defendant. And therefore there was no occasion to allot.
Para 17 slot.
Para 18 भी तो पढ़ेंगे ना?
हाँ हमारे 18 भी है.
18, 17 दोनों साथ में पढ़ेंगे. 16, 17, 18 पढ़िए साथ.
The defendant number 1 to 5 have no legal right to evict the plaintiff from the suit premises since there is an allotment in favor of the plaintiff by the defendant number 4. The legality of the allotment have not been questioned by the defendant number 1 to 3. Neither there is evidence for such legality of the allotment. Hence present scenario, defendant number 1 to 3 have no right to evict the plaintiff from the suit premises. Now, for the sake of convenience, issue numbers 7, 8, 9 and 10 are being decided together. The plaintiff in the present case have prayed for possession of the premises till the pendency of the prayer before the defendant number 4. Said prayer have been decided, but legality of the prayer about the manner of the allotment have not been properly proved by the plaintiff. Although it has been admitted by the defendant number 4, but in view of the prayer for non-cancellation of the allotment by the defendant number 1 to 4, this issue also decided against the. But there is a admission of the defendant number 4.
पढ़िए ना आगे, आधा मत पढ़िए.
The plaintiff have provided the allotment of the suit premises during the pendency of the suit, but legality of such allotment is under challenge. The plaintiff has not provided any evidence with regard to this said allotment. Hence, this issue is also decided against the plaintiff. As far as possession of the plaintiff over the suit premises is concerned, the possession has been denied to be permissive, but the earlier allotment in favor of the defendant number 2 gives the idea about the possession to be permissive. But since the plaintiff has denied about the permission to be permissive, hence he is not admitting the relationship of landlord and tenant, and in view of the prayer before the defendant number 4. This issue is not in favor of the plaintiff. The plaintiff and defendant have been provided allotment before cancellation of allotment in favor of the defendant. The allotment in favor of the plaintiff have been made by the defendant number 4. There is nothing on the record to show that earlier allotment in favor of the defendant has been cancelled prior to making of the allotment in favor of the plaintiff. Therefore, in view of absence of the legality of the rejection of the allotment against the defendant, the allotment in favor of the plaintiff cannot be decided at this juncture. Now, in view of the discussion, I find that the relief prayed by the plaintiff is infructuous, as the relief prayed by the defendant number 1 cannot be decided in its favor in view of the allotment in favor of the plaintiff. फिर मेरे favor में बोलना. There is no evidence on the record the allotment in favor of the defendant has been cancelled prior to allotment in favor of the plaintiff. Hence, the suit here will be dismissed along with counter claim. But there is the admission of the defendant number 4.
इससे क्या admission? Admission से क्या मतलब? Allotment हो गया. But the point is that the suit was ultimately not allowed because
the suit has become infructuous
by virtue of the subsequent allotment. But there was no cancellation.
Subsequent, yes, it is admitted fact that
There was cancellation.
there was no cancellation of the defendant number 2 lots.
If it is an admitted fact, तो बिना cancellation के fresh allotment कैसे होता?
But that order was not challenged by the defendant number 2. They challenged the counterclaim before the learned first appellate court lawsuit. He did not challenge the findings of the learned trial court relating to allotment of the quarter or another materials lawsuit.
And what is the reason for allowing the counterclaim by the first appellate?
Para 14 lawsuit, learned appellate court.
The defendant went in appeal.
Defendant number 2 filed an appeal. I was not filed the appeal.
You did not file that.
Yes.
Although the suit was dismissed.
Suit was not dismissed. Suit has become infructuous. Para 14 lots. First line is important lawsuit passed by the learned first appellate court.
Yes.
This appeal has been filed against the judgment and decree dated so and so passed in title suit number so and so, whereby the counterclaim the appellant was dismissed.
Yes. Appellant was only agreed
The
by rejection
defendant
of
number two
counterclaim.
not the agree by the judgment and decree passed by the time only the counterclaim was dismissed. The counterclaim was not registered, not advertisement court fee was paid,
That's right.
and the learned first appellate court has gone into merit of the case so far as counterclaim is concerned also. 12-14 also. Let consider the appellant submitted the appeal has been filed against the
Para
counterclaim.
14 के पहले para 5.8
Para
5.8
5.0.
page number 16.
No, yes. The quarterly in question has already been allotted in favor of the plaintiff. So now the suit of the plaintiff, futile as the relief sought for the plaintiff has already been decided in his favor. The plaintiff is not entitled to get any other relief in the suit, hence the suit is being dismissed this course. I think that this is the submission of the appellant.
This is a submission of finding of trial court. इसके बाद इनका फाइंडिंग कहाँ पर?
4.13 also, this is the claim of the defendant number 2. 4.13. Page number 13, internal page number 13. This is the claim of the defendant number 2. The defendant number 2, Vakil Ansari, has prayed for following relief. Upon adjudication, it is declared that defendant number 2 has got valid right upon the quarter number of so and so now so and so allotted to him by the defendant number 4 on 18/3/1994, and the plaintiff is liable to be evicted therefrom, and the defendant number 2 be put in fast possession over the quarter number 1D government colony Gomia through the process of the court. But my submission is how the learned first appellate court has gone into merit of the case so far is counterclaim. Because the advertisement court fee was not paid lawfully, it was not registered, it is required to be registered lawfully.
काउंटर क्लेम अलाउ करने का रीजन क्या था? टेनेंसी राइट डिक्लेयर कर दिया है
उसी आधार पर. But the areas of rent were paid by the plaintiff also. So far as tenancy is concerned also. Therefore, also during the pendency of the suit, water has been
पेज
allotted.
नंबर 36 से पढ़िए पैरा नंबर 36
Para number 36.
इंटरनल पेज 36 पढ़िए लर्निंग ट्रायल कोर्ट
The learned trial court has dismissed the counterclaim on one of the premises. No relief has been sought for cancellation of allotment deed. The reasoning the trial court is not renewable for the alleged allotment paper, if any, is between the plaintiff and defendant number 4. Defendant number 2 is not party to that deed, so he cannot ask for cancellation of deed. Hence, on the premises of the control cannot be dismissed.
आगे पढ़िए
Further, in this case, neither the plaintiff nor the defendant number 4 has filed quarter allotment deed of the plaintiff. There is only oral admission on the part of the defendant number 4 with regard to such allotment. there is no oral evidence worthy to be believed upon the regard to the allotment of disputed quarter in favor of the plaintiff or respondent. But the quarter has been allotted by the defendant number 4 lordship, who is the competent authority
Para
lordship.
38.
Now the question arises whether the admission with regard to the allotment is sufficient to invalidate the allotment deed of the defendant number 2 or oblique appellant or dismiss the counterclaim. At this, I discuss the necessity of the document of convenience. In case of such, it has been held that cardinal rule of evidence that where the written statement, written documents exist, it shall be produced as being the best evidence of its contents. In so and so case, it has been held that section 91 provides best evidence rule. The general rule and not inflexible rule is that in case of written instrument, any other evidence excluded either as a substitute for the such instrument or contradict. This is not the relevant law. There is a judgment of the Honorable Supreme Court 2011 SCC page 402, in which the Honorable Supreme Court held that admission is a best piece of evidence, lordship. And the defendant number 4 admitted before the learned trial court, lordship. The quarter has been allotted to plaintiff, lordship.
Para 41 में देखिए.
Furthermore, the plaintiff has not filed any WS with regard to the counterclaim filed by the defendant number 2. The defendant number 2 has not filed any. Thus, the counterclaim remains without being assailed by any rival party. In a way, counterclaim is ex parte. In such circumstances, the result of counterclaim binding upon the plaintiff. More so, the DW6 and the defendant number 2 has shown his readiness to deposit the areas of the rent. The admission of DW2 that the sent bank draft to areas of rent due to defendant will also prove his readiness to pay the area. DW1 Ajay Kumar has also admitted the factor of the bank draft in para 11. Thus, there cannot be any doubt that the defendant would not execute his duty for being tenant of the defendant number 4. But the advalorem court fee has not been paid, lordship. And there is a admission of the defendant number 4 that quarter has been allotted to the plaintiff, lordship. And admission is the best piece of evidence in view of the judgment 2011 SCC page 402. Unfortunately, I am not proud.
So still your whatever be the judgment of the trial court, that will be paid whatever it is.
Yes.
Only the counterclaim.
Counterclaim. Only the counterclaim.
So non-registering the counterclaim separately.
Yes.
And non-payment of ad valorem court fees.
Court
Had the
fees.
counterclaim been registered separately,
Separately.
there would have been stamp reporting, and then the
And
court would have asked
all the
for-
parties will adduce evidence, lordship. So
will
far as
adduce
counter
evidence.
and the issue is required to
And
be.
the learned appellate court has recorded that counterclaim, no written statement was filed to the counterclaim. Since it was not registered, therefore no written statement was filed.
But finding of the learned trial was also bad in law in view of fact that no issue was framed, no ad valorem court fee was. How the learned trial court came into conclusion that and dismissing the counterclaim, lordship.
Rather, the counterclaim, there should not have been any pronouncement on counterclaim.
Yes, correct.
देखिए सीपीसी का हम लोग को ऑर्डर
Order 8, Rule 6A.
ये 6C क्या है? 6B 6C सब पढ़ी।
Counterclaim to be stated where any defendant seeks to rely upon any ground as supporting the right of counterclaim, he shall in his written statement state specifically he does so by way of counterclaim. ठीक है, अपना written statement में दिए हैं. Exclusion of the counter where a defendant sets up a counterclaim and plaintiff contended the claim thereby raised ought not to be disposed of by way of counterclaim, but is in an independent suit. The plaintiff may any time before the issue are settled in relation to counterclaim apply to the court for an order that such counterclaim may be excluded and counter may on the hearing of the such application may such orders as think fit.
तो अगर अलग से सूट फाइल करने का होगा
अगर होगा तब
वैसे तो नॉर्मली काउंटर क्लेम इज टू बी इंस्टीट्यूटेड एज अ काउंटर क्लेम टू बी ट्रीटेड एज अ सूट
Suit.
काउंटर सूट क्रॉस
counterclaim is to be treated as a plaintiff.
आगे बढ़ते हैं
Effect of this continuation on suit. If any case in which the defendant sets up a counterclaim, the
दैट्स
suit
राइट 6E पढ़िए
60. Default of plaintiff to reply the counterclaim. If the plaintiff makes default in putting a reply to the counterclaim made by the defendant, the court may pronounce judgment against the plaintiff in relation to counterclaim made against him or make such order in relation to counterclaim as it is think fit. पर यहाँ दो चीज नहीं आएगा क्योंकि यहाँ एडवर्टरम कोर्ट फी पेड नहीं हुआ इसलिए कोर्ट हैज नॉट गॉन इनटू मेरिट ऑफ द केस.
दिस इज वन पार्ट और एक है ऑर्डर 4 रूल 1 है
Suit to be commenced by plaintiff. Every suit shall be instituted by presenting plaintiff in duplicate to the court or such officer as it appoints in his behalf. Every plaintiff shall comply with the rules contained in Order 6 and 7 so far as they are applicable. The plaintiff shall not be deemed to be duly unless it complies with the requirement specified in sub rule 1 and 2.
एंड ऑर्डर 6 and 7 क्या है
Order
6 and 7
6 and 7.
Order 6 is pleading generally.
Pleading amendment of the plaint, strike off
6 and 7 क्या है
7 is the relief to be stated clearly, Lordship. Order 7, Rule 7. Order 7, Lordship. The particulars to be contained in the plaint in money suit, subject matter in the plaintiff suit. This is an important Lordship. And Rule 7, relief to be especially stated. Return of plaint, rejection of plaint.
Order 7 Rule 11 देखिए
The rejection of plaint. The plaint shall be rejected in the following cases where it does not disclose a cause of action, where the relief claimed is undervalued and plaintiff on being the required by the court to correct valuation within time to be fixed by the court fails to do so, where the relief claimed is properly valued but plaintiff is written upon paper insufficiently stamped.
या insufficient court fees एक ही बात है
Yes.
तो अगर मान लीजिए ये रजिस्टर होता तभी ऑफिस पॉइंट आउट करता
पॉइंट आउट जब कोर्ट फी देता था वो रजिस्टर्ड होता.
नहीं पहले तो रजिस्टर होता है एज अ काउंटर क्लेम उसमें
ठीक है।
डिफेक्ट लगता कि भाई इतना
हाँ,
कोर्ट फीस
इतना अपना कोर्ट फी की जरूरत है मगर वो स्टाफ रिपोर्टिंग भी नहीं हुआ,
वो भी नहीं हुआ क्योंकि इंस्टीट्यूट ही नहीं हुआ
इंस्टीट्यूट ही नहीं हुआ.
देन देयर वुड बी अ सिचुएशन कि वो रिजेक्ट होता कि नहीं होता
कोर्ट देखता बात को
कोर्ट देखता बाद में, लेकिन चूंकि इंस्टीट्यूट नहीं हुआ ना कोर्ट फीस उसका पेमेंट हुआ.
लर्नर ट्रायल कोर्ट का फाइंडिंग आ गया कि हम डिसमिस करते हैं काउंटर क्लेम,
हाँ.
but appellate court has gone into merit of the case so far as counter claim is concerned.
ठीक. How the learned counsel is bearing on behalf of the parties. This appeal has been admitted by the order dated 13/2/2025 on the following substantial question of law, para 11 में. आपने लिखा है इसको रिमांड होना था बाय
हाँ.
फर्स्ट अपीलेट कोर्ट.
जी, हमारा सबमिशन है रिमांड. But I feel lordship may pass the order in accordance with law and as you are. चूँकि काउंटर क्लेम रजिस्टर्ड नहीं हुआ, उसको फाइंडिंग आ गया तो रिमांड ही होगा, हमारा रजिस्टर करें और सुनिए. This is my submission.
तो एक बात बताइए, कोर्ट का गलती से कोई आदमी सफर कर सकता है?
नहीं,
कोर्ट का गलती है ना, रजिस्टर करना चाहिए.
करना चाहिए.
They should have registered it.
यस, वो चीज हम भी बोल रहे हैं, रजिस्टर्ड होना
So
चाहिए.
रिमांड तो वही होगा ना,
ट्रायल कोर्ट में ही जाएगा. दोनों जजमेंट सेटिस्फाइड करके दिस इज माय सबमिशन लॉर्ड मे बी रिमांडेड फॉर डिसाइडिंग इफ केस आफ्टर रजिस्टरिंग द काउंटर क्लेम एंड आफ्टर पेइंग द एड वैलोरम कोर्ट. एंड टाइम में भी फ्रेम लॉर्डशिप द एड वैलोरम कोर्ट भी
छूट तो आपका डिसमिस हो ही चुका है. अब काउंटर क्लेम डिसाइड होगा जो होगा.
डिसाइड होगा तो हम अपील करेंगे. डिसाइड होगा तो हम अपील करेंगे.
Because suit has now been dismissed. उससे तो आपको कोई ग्रीवेंस नहीं
नहीं, कोई
है.
ग्रीवांस नहीं, चूंकि
और उनको भी कोई ग्रीवेंस
कोई
नहीं.
ग्रीवांस नहीं. हम चूंकि हमारे फेवर में अलॉटमेंट हो चुका है पोजीशन में.
That would be the fair order.
जी,
कोर्ट के गलती से nobody should suffer.
यस. सिर्फ उसमें जो डिमांड किया जाए सिर्फ काउंटर क्लेम.
Only for counter.
Only for counter.
Only for
Other
counter.
judgment will remain lost.
हाँ, only for counter.
Lost. Okay.
This appeal has been filed against the judgment and decree dated 30/4/2022 within bracket decree signed on 13/5/2022 passed by the District Judge 1 Bermo at Tenugat, whereby civil appeal number 25 of 2017 decreeing the civil appeal number 25 of 2017 has been allowed, and the counterclaim of the defendant number 2 has been decreed, and consequently the judgment and decree dated 23/2017 within bracket decree signed on 4/4/2017 passed by learned civil judge within bracket junior division bracket close Bermo at Telugu entitled suit number 35 of 2012 dismissing the counter claim has been set aside. ध्यान से सुनेंगे.
जी.
The learned counsel for the petitioner, for the appellant, has submitted that the suit was filed with a prayer that the defendant number 1, 2, 3 were not entitled to evict the plaintiff forcibly till the pendency of the prayer of the plaintiff before the defendant number 4, within bracket the housing board, regarding allotment. He has further submitted that the original allotment was made in favor of defendant number 2, which was prior in point of time, but the plaintiff came in occupation of the suit premises and the suit was filed during the pendency of the application before the defendant number 4 filed by the plaintiff. During the pendency of the suit, the allotment was made in favor of defendant number 4. Which was an admitted fact from the side of the defendants. He has further submitted that defendant number 2 एक ही defendant number 1, 2, 3 थे ना.
But counter claim was filed by the defendant number 2.
Defendant
Because the quarter was allotted to the defendant number 2.
He has submitted that in the written statement filed before the court, the defendant number 2,
Written
in
statement was filed by
continuation to the written statement,
the written statement was filed by the defendant number 1, 2, 3.
the learned counsel has submitted that the written statement was jointly filed by the defendant number 1, 2,
1,
3.
2, 3.
And in the written statement itself, defendant number 2 had incorporated a counterclaim
Lots.
stating that the quarter was legally allotted to defendant number 2 and he was ready to deposit the arrears of rent to the housing board, and defendant number 2 had a valid right to get the quarter in vacant possession from the plaintiff. It was also asserted by defendant number 2 in the counterclaim that the plaintiff was only having permissive possession and there was no allotment in favor of the plaintiff.
The relief of
The-
the counterclaim has been mentioned in paragraph 4.13 of the learned appellate court law.
The
Internal page 13 laws of the learned first appellate court.
The learned counsel has submitted that the entire counterclaim as made in the written statement has been quoted in paragraph 4 of the
4.13.
appellate court judgment.
4.13.
पूरा ही quoted है 4 sir.
ठीक.
At paragraph 4 of the appellate court judgment, including the relief prayed in the counterclaim,
Lots.
he has further submitted that the counterclaim was valued at rupees 30,000 and the defendant number 2 also asserted that he was ready to file court fees thereon for adjudication of his claim. 4.12 में ये बोले हैं.
Suit value be 30,000, counter claim be 30,000.
The learned counsel has submitted that the suit was valued at rupees 30,000 and counterclaim was also valued at rupees 30,000. He has submitted that there was no issue framed with regard to admissibility of the counterclaim filed by defendant number 2. Although an issue was framed as to whether the defendant number 2 was entitled for, the defendant number 1 to 3 were entitled for possession of the property. And 1 and 3 लिखा हुआ है. 1 and 3 लिखा हुआ है. 2 तो लिखा ही नहीं.
Internal page 3 lordship, the learned trial court.
The learned trial court had framed an issue as to whether the defendant number 1 and 3 had right to evict the plaintiff from the sued property, although the counterclaim was filed by defendant number 2. The learned counsel has submitted that at no point of time the counterclaim was registered and consequently the defendant number 2 did not even pay the court fees, ad valorem court fees on the counterclaim as was required to be paid, as counterclaim is treated as a separate suit in the nature of cross suit. The learned counsel has submitted that since the counterclaim was not registered, there was no occasion for the plaintiff to file a written statement to the counterclaim.
As well as by the defendant number 4, the executive engineer.
As well as there was no occasion for the defendant number 4 to file any response to the counterclaim. The learned counsel has submitted that ultimately the learned trial court, though dismissed the suit, but recorded that the suit premises was already allotted in favor of the plaintiff. The learned trial court also dismissed the counterclaim. The learned counsel has submitted that since the allotment was already made in favor of the plaintiff, there was no occasion for the plaintiff to file an appeal, as the allotment, as the suit had become infructuous for all practical purposes. But the defendant number 2 filed an appeal challenging the rejection of counterclaim. He submits that the appeal filed by the defendant was allowed and filed by the defendant was allowed primarily on the ground that no written statement was filed either by the plaintiff or the defendant number 4 to the counterclaim made by the defendant number 2. The learned counsel has submitted that in absence of separate registration of counterclaim and payment of ad valorem court fees by the defendant number 2, the counterclaim itself could not have been a subject matter of adjudication, and in fact no issue was framed with regard to right of the defendant number 2 to evict the plaintiff from the sued property. He submits that these aspects of the matter has not been properly considered by the learned first appellate court, and consequently the
One more clear lawsuit. The appeal is also not maintainable lawsuit because the counterclaim was not is registered by the trial court lawsuit.
this aspect of the matter has not been properly considered by the learned first appellate court, and therefore the substantial question of law has been framed by order dated 13/2/2025. The learned counsel has submitted that since the counterclaim itself was not registered, therefore there was the appeal itself was not maintainable. He has further submitted that though the suit stands dismissed, but the counterclaim has to be treated as a separate suit, and therefore for the interest of justice it would be better to remand the matter to the learned trial court for instituting the counterclaim as a separate suit, and if the defendant number 2 chooses to pay the court fees on the counterclaim, the court may proceed in accordance with it. However, he has submitted that for this purpose there is no need to restore the suit itself,
Yes.
as counterclaim by itself is a separate suit.
Separate.
Yea,
Yes.
the learned counsel has also relied upon the judgment passed by Honorable Delhi High Court
Para 60.
reported in 2019 Supreme within bracket Delhi 1959, paragraph 6, to submit that the Honorable Delhi High Court has also held that every counterclaim is required to be registered by the court, and only thereafter summons can be issued by the court. The time for filing the written statement runs from the date of service of summons. He has also submitted that the Honorable High Court of Delhi has also issued necessary guidelines in connection with registry of counterclaims, such that no error in registering the counterclaim occurs by the learned trial. He has submitted that the same judgment has been passed by Honorable Delhi High Court in the context of Commercial Courts Act, but the principles of law, so far as registering of counterclaim is
We apply
concerned,
in all
are
cases.
one and the same. The learned counsel appearing on behalf of the respondent number,
1 to 3.
respondent number 1 to 3, who are representing the defendants,
Dependents.
has submitted that he has been instructed by his clients not to advance any arguments with respect to the merit of the case, and therefore he submits that appropriate order based on the provision of law be passed. Yeah.
Or it may be remanded back.
Or it may be this. बोलिएगा वही लिखाएंगे. फिर आपका क्लाइंट आपको चार्ज नहीं करे बस.
नहीं वही इंस्ट्रक्शन ही है
However, on the point of law as an officer of the court, the learned counsel has submitted that it's a case where the where the matter with regard to counterclaim be remanded to the learned trial court for its registration, and the defendants may not suffer on account of error committed by the concerned court. Okay?
public.
After hearing the learned counsel for the parties, this court finds that the suit was filed by the plaintiff for the relief that the defendant number 1, 2, 3 were not entitled to evict the plaintiff forcibly till the pendency of the prayer before the defendant number 4. It was the specific case of the plaintiff that the respondent number 4, defendant number 4, representing the housing board, had constructed colonies consisting of numerous quarters, and the plaintiff had applied for allotment on 4/9/2012 and the defendants and the other defendants forcibly entered into the house and occupied one room. The matter was reported to the police, but the defendants could not be evicted from the premises. And ultimately the suit was filed. It was a case of defendant number 1, 2, 3 in the written statement that required notice under section 80 CPC was not served upon the defendant number 4, and that the suit was otherwise barred under the provisions of Specific Relief Act.
In section 80 of the CPC.
Under section 80 of the CPC and section 33 and 34 of the Specific Relief Act. It was also asserted that it was denied that they have forcibly entered into the house of the plaintiff and occupied one room on 28/11/2012. Rather, the defendant number 1 to 3 claimed that defendant number 2 was allotted the same quarter on the basis of rent on 18/3/1994 by the then executive engineer of the housing board at Hazaribagh. And they were in peaceful possession of the property. The case of the defendant number 2 was that the defendant number 2 was validly allotted the property on rent, and he had valid right to get the quarter in vacant possession from the plaintiff. and the defendant number 2 through the counterclaim prayed that the plaintiff be evicted from the suit property and the defendant number 2 be put in possession of the property. The defendant number 4, representing the housing board, also filed a written statement stating that the housing board had allotted the quarter to the plaintiff on 18/3/2013 as per law and the rules of the housing board. And since the quarter was already allotted in favor of the plaintiff, therefore the suit of the plaintiff was futile and the relief sought for by the plaintiff has already been decided in his favor. Specific written statement. The learned trial court framed the following issues for consideration.
The finding is para 14.
And
Para 15.
the finding in connection with issue number 1 to 6 has been recorded in paragraph 15 of the trial court judgment. 15 to 18. This court finds that the trial court held that the prayer of the plaintiff had become infructuous and the relief prayed for by defendant number 1, 2, 3 could not be decided in their favor in view of allotment in favor of the plaintiff, and there was no evidence on record that the allotment in favor of the defendant has been cancelled prior to allotment in favor of the plaintiff. Hence, the counterclaim was also dismissed. The records, this court further finds that the defendant number 2 filed appeal only to the extent it related to rejection of his counterclaim. The learned first appellate court has recorded, has allowed the counterclaim, has recorded that the only point for determination was whether the learned trial court has rightly dismissed the counterclaim of the appellant, reading back to defendant number 2. The learned first appellate court recorded that recorded the finding in paragraph 36, 37 as under court conduct. The learned first appellate court further recorded in paragraph 41 of the judgment that the plaintiff did not file any written statement with regard to counterclaim filed by defendant number 2, and the defendant number 4 had also not filed any written statement, and thus the counterclaim remained without being assailed by any rival party, and in a way the counterclaim was ex parte. In such circumstances, the result was that the counterclaim was binding upon the plaintiff. Paragraph 41 of the judgment passed by the learned first appellate court is quoted as under. The learned appellate court after having recorded that the counterclaim was not opposed by by the plaintiff or even by the defendant number 4 by filing a written statement, and the counterclaim was practically ex parte, ultimately allowed the appeal, and the judgment of dismissal of counterclaim passed by the learned trial court was satisfied. The records received from the concerned court reveal that the written statement itself contained the counterclaim filed by defendant number 2. But the counterclaim as such was never set. उसी में अलग से number हो जाता है. Counterclaim as such was never numbered or registered separately. And consequently, there was no occasion. The records also reveal that although the defendant number 2 in the counterclaim stated that he was ready to pay the court fees for the counterclaim, and the counterclaim was valued at rupees 30,000, but since the counterclaim was not registered, there was no occasion for the defendant number 2 to pay any court fees on the counterclaim. Since the counterclaim was never registered, therefore the period to call for written statement on the counterclaim also never commenced, due to which apparently neither the written statement to the counterclaim was filed by the plaintiff nor it was filed by the defendant number 4. This court is of the view that the learned first appellate court has not examined the records of the learned trial court by observing that the counterclaim remained ex parte, as neither the plaintiff nor the defendant number 4 filed their written statement to the counterclaim. This court is of the view that the counterclaim having not been registered, there was no occasion for the plaintiff or the defendant number 4 to file any written statement in that, and therefore the period to file written statement to the counterclaim never commenced. इसके बाद इसको कोट करेंगे, ठीक है? Order 826 ACPC. And then order 4 rule 1 and 2.
And appeal is also not mentioned. Since the counterclaim was not registered,
in view of the fact that the counterclaim was not separately registered, there was neither any occasion for the learned trial court, was never separately registered, and consequently no court fees was also paid on the counterclaim, and the plaintiff as well as the defendant number 4 were never called upon to file a written statement. The learned trial court has also not considered this aspect of the matter by rejecting the counterclaim. Therefore, the rejection of counterclaim by the learned trial court and the judgment allowing the counterclaim by the learned first appellate court, both cannot be sustained in times of war. The fact remains that the counterclaim was filed along with a written statement raising the counterclaim of defendant number 2 but the same was never registered by the court. The law is well settled that none of the parties should suffer on account of fault of the court. Therefore, this court is of the considered view that the counterclaim filed by the defendant number 2 is required to be registered, and upon registration of the counterclaim, an opportunity is required to be given. Counterclaim is required to be registered upon payment of court fees या defect निकालेंगे तब.
डिफेक्ट पहले तो रजिस्टर्ड होगा उसके बाद डिफेक्ट
हाँ.
होगी.
And upon payment of the court fees as may be required under law, the procedural, the concerned parties be called for to file a written statement in accordance with law. Therefore, consequently, the judgment passed by the learned trial court rejecting the counterclaim and the judgment passed by the learned first appellate court allowing the counterclaim are hereby set aside to the enforcing extent. बस इतना ही बहुत है. और ये जजमेंट में इस तरह का गाइडलाइन यहाँ पे ऐसे रेगुलर होता है क्या? It's something very regular. Counterclaim are not being registered.
नहीं, अदर केसेस हम देखेंगे रजिस्टर्ड होता है.
बहुत सी जगह
Yes.
रजिस्टर्ड होते हैं, बहुत जगह नहीं होते हैं.
Counterclaims are being registered or not registered?
Registered.
Registered. ये कैसे इस तरह से हो गया? अजीब तरह से हो गया. तो आपका वेपन आपको तो आपका काउंटर क्लेम परसू करने के लिए आगे करना पड़ेगा.
पार्टीज अपना इंटेंटेड होंगे करने के लिए.
They'll do it themselves ना. कोई डेट तो यहाँ से देने का
नहीं,
जरूरत
डेट सबको नोटिस करेंगे पूरा.
नहीं, इनको थोड़ी नोटिस करेंगे.
हम लोग
आप लोग को करेंगे, आपको नोटिस होगा तब
हम जाएंगे. जब कोर्ट फी वगैरह दे देंगे, रजिस्टर्ड होगा तब नोटिस होगा.
तो कोर्ट अब रजिस्टर करेंगे तब तो ये आएगा कि हाँ एड वॉलरम कोर्ट फीस दिया
हाँ,
है.
तो आप ही को न जाना पड़ेगा वहाँ पर. The needful be done by the learned trial court within a period of latest by, I'll just give a date also, by 31st of July. उनको जो करना होगा अपना करेंगे. एक चीज़ और. A substantial question of law is accordingly answered in favor of the appellant and against the
Defendant number
defendant number 2. Only 2?
and against ex party order against the defendant number 4.
Ex party.
हाँ, because उनको भी नोटिस हुआ, एपीआर नहीं किया.
तो उनके अगेंस्ट में क्या, उनके तो क्या ही होगा. I think that should be insufficient. बाकी हम करेक्शन करेंगे. I'll take my own time.
जी.
Yes. What are they?
Serial number 11 from the Peggy project, there was a direction to file counter affidavit. So they are filing it today and it's staying and will be taken also.
What is your affidavit?
Leadership there was a specific date of the court with regard
The order has come?
with regard to leadership, the order of the 40 case that has been mentioned in the leadership fee of the legislation.
Yes.
Yes, leadership, that is the correct date that has been mentioned. The certified copy of the 40 cases also been annexed to the
So the your grade is different.
there was some mistake.
There's
in
some
the-
mistake.
Yes, in the date. That was.
Is the mistake is admitted or it is a
No,
dispute?
it is earlier they were relying that is the date of the new order. However, on last occasion it is part order, part date which is not complete in the certified copy that was submitted by the council for the petition. However,
You
on
need to carry out certain amendment? No.
That I have to check the content. That is when I was.
Please check it. You have got the copy?
No, ladies,
Where
I
will
have
you
submitted it.
You are filing it during the course of the day?
Yes.
This is serial number?
11.
11. The learned counsel for the parties are present. The learned counsel for the state submits that. The learned counsel for the state is permitted to file the required affidavit during the course of the day, after serving copy upon the petitioner as well as the private respondent. Counsel for the petitioner prays for adjournment. How much time do you need?
Next.
Post in the next meeting, corresponding आज कौन सा दिन है?
Wednesday.
Corresponding Wednesday. Okay. आपका कुछ है? कौन सा? हाँ, disposed of in aforesaid terms.
Maybe allowed because the judgment decree.
अच्छा ठीक है, allowed in aforesaid terms. ठीक है?
जी.